I shall talk about the cooperative law in Japan and the Workers Cooperative Act that has just been enacted last December. It's a newest law in Japan. I am a part of the legal frame analysis group in charge of the East Asia. As Asia is too vast and diverse, so we have decided we are writing the sub-regional reports. For instance, East Asia, Southeast Asia, South Asia, West Asia, Central Asia, and the Pacific. And I am in charge of the East Asia report. And in this East Asian report, I have touched upon 4 countries, namely Japan, South Korea, China, and Mongolia. The Chinese researchers couldn't give us the complete report, so only I can rely on their interviews made by the 3 Chinese researchers, scholars. But I found there's very large difference even in East Asia. But today I shall discuss about the corporate law in Japan that is has many common things with South Korean law, because Korean Peninsula has been the Japanese colony, so the South Korean legal system had been influenced by the Japanese one. Later on, I shall touch upon that. So I am now taking the slides to explain, and today I shall, my presentation is as follows. After introduction, I shall very briefly describe the evolution of corporate law in Japan, and I shall pick up some overview of the Japanese corporate law and some characteristics aspects of corporate law in Japan. And then I will focus on the Workers Cooperative Act enacted in December 2020, just 3 months before, and Workers Cooperative Act's impact to the existing legislation. Then I shall conclude my discussion. First of all, you may know that the Japanese cooperatives have grown to sheer size organizations in some aspects. For instance, agriculture cooperatives are ranked amongst the largest for agriculture, insurance, and banking sectors in the World Cooperative Monitor, while the membership of consumer cooperatives in Japan accounts for more than 70% of counterparts in Europe, affiliated with Eurocoop. However, the Japanese cooperatives are institutionally and organizationally divided in Japan's political economy, lacking the sense of identity as a cooperative sector. That is the largest question. This phenomenon can be explained from the prevailing socio-economic environment, while it is partly due to the peculiar legal framework that has given impacts in the past-dependent evolution of cooperatives. The Japanese legal system is based on a statute law following French-German tradition, and it has influenced South Korean legal system and Taiwan legal system. But I shall touch upon later. So first, I shall very briefly describe the evolution of corporate law in Japan. I have written an article to the book edited by the Vienna University several years ago, and I am now writing an article on the characteristics of the Japanese law for the new publication dedicated to Hagen Henry. So I have already done two major works for the Japanese cooperative law, the history and the current characteristics. So the first I have to mention about the Industrial Cooperative Act that was enacted in 1900s following the German legislation, Raiffeisen system. It regulated all types of cooperatives for marketing, supply, credit, and production. And this production was later replaced by services. And this law has focused on rural cooperatives, but it covered also urban cooperatives as well. For instance, consumer cooperatives, credit cooperatives operating in the cities. But the Japan surrender and Allied force occupation after the World War II impacted the whole legal system, including the Constitution and the Civil Code. The Constitution, it is said, the Constitution was made by the Americans. It is, even now, it is often criticized by the right-wing people. A general headquarters of Allied force took the measures for democratizing the economy through legitimizing trade unions, introducing Anti-Monopoly Act to dismantle Zaibatsu, the business groups, and implementing the thorough agrarian reform to break up landlord system. And Agricultural Cooperative Act, now referred as ACA, was enacted in 1947 to cement the effects of agrarian reform. Agricultural cooperatives took over the parastatal organizations created by merging industrial corps with mandatory agricultural societies to mobilize resources during World War II. So now we have the separate legislations based on industrial policies. Consumer Cooperative Act, 1948, Fisheries Cooperative Act, 1948, Small and Medium-Sized Enterprise Cooperatives Act, 1949, and Act on Cooperative Banking, and Shinkin Bank, Credit Cooperative Bank Act, 1951, Labor Bank Act, 1953, Tobacco Growers Cooperative Act, 1958, First Owners Cooperative Act, 1978, and Norinchukin Bank Act in 2001. And you may notice that after the name of law, the ministry's names are shown. For instance, in case of Consumer Cooperative Act, that is regulated by Ministry of Health, Labor and Welfare. Fishery Cooperative Act is regulated by Ministry of Agriculture, Fishery and Forestry. And Small SME Cooperatives Act is regulated by Ministry of Economy and Trade and Industry. And banking acts are regulated by financial service agencies, etc. So they are very much related to the industrial policy and its regulators. And finally, Workers Co-operative Act, WCA, was reenacted in the eve of 2020 to be regulated by Ministry of Health and Labor Welfare after campaigning of more than 2 decades. Such an evolution has resulted in the peculiar legal system, often referred as Galapagos syndrome. In addition to these laws, there are 2 regulations applied to all types of cooperatives. One is the competition law, that was enacted after the World War II, following the example of the Kappa-Volstead Act in 1922, often referred as the Magna Carta for farmers' cooperatives. And Corporation Tax Act provided a favorable tax treatment for all cooperatives in the Annex 3, but the differential in tax rate with conventional companies had been dwindling over decades. Later I shall touch upon this. So as you can see, the overview of Japanese cooperative law, the fragmented cooperative legislation. The most striking feature of the Japanese cooperative legislation is the lack of the general law. This reflects the legal administration system characterized by as silo formation in the political economy. Masahiko Aoki, the economist, puts it bureau pluralism. Most of the countries have a unified cooperative law or general law or basic law in addition to the specific laws. South Korea was in the same situation with 8 cooperative laws and 8 ministries. But the Framework Act on Cooperatives was enacted in 2011. That has a great breakthrough and made great impact to the Korean society. The elements of organization, the second characteristic is the elements of organizational laws mingle with those of business laws. In the Japanese juridical system, there are many cases where the legal elements of organization concerning the establishment and operation, finance, and these organizational law elements are mixed with the legal elements of businesses. That restricts the freedom of business for the sake of the public goods. Thirdly, the strong control and the promotion by ministries in line with the industrial policies. The specific cooperative laws are characterized by the principal approval by the competent government agencies and strong regulation and supervision. This has contributed to the formation of the industrial coalition or triangles by ministries, member of parliaments, and trade association. It's very typical in the agricultural cooperatives. Ministry of Agriculture, Liberal Democratic Party, and JA Zenchu, the Central Union of Agricultural Cooperatives, formed so-called agricultural policy triangles. There are special laws to promote their reorganizations, mergers, and banking system through policies and tax measures. Accordingly, Japan-style agricultural cooperatives are often seen as a mixture of the state agency to promote agricultural policy, the pressure group to protect farmers' interests, and the cooperatives per se. And the fourth problem is hindering the free establishment of cooperatives to meet new needs. The current provision on membership and business in specific cooperative laws make it difficult to establish new types of cooperatives whose activities are designed to meet new needs caused by socioeconomic changes. For instance, it is not possible to establish mixed production and consumption type cooperatives, consumer and agricultural cooperatives, mixed type. We can't establish it. Or we cannot establish multi-stakeholder cooperatives. It is not possible to establish cooperatives that meet the needs of production distribution of renewable energy and address social inclusion of the disabled persons, such as social cooperatives in Italy. Finally, delay in modernization of cooperative legislation. Okay. The New Companies Act of 2006 became a general law on companies, integrating 4-5 laws on companies. The General Incorporated Association Foundation Act, or General Nonprofit Act of 2008 was intended to be a general law for nonprofits. So both the for-profit companies and non-profit entities that are basic acts or general laws, but in cooperatives, there is no such a general law. Some characteristics very briefly. Purpose. Each law doesn't have any uh, description, any provision on the purpose of cooperatives or definition of cooperatives. Each law, each law just stipulated the purpose of law based on the industrial policy. For instance, Article 1 of the Agricultural Cooperative Act reads, this law aims at improvement of the agricultural productivity and the rising up of the economic and social position of farmers through facilitation of agricultural cooperatives. So cooperatives are seen as a means to attain the objectives of the industrial policy. That is very typical way of provision, providing for the purpose of the law. As I have mentioned, establishment, the cooperatives are established upon government approval or permission, while they need to acquire the license for banking businesses from the Financial Service Agency, and they can, but in case of the insurance business, they can conduct kyosai insurance business under individual cooperative laws because of the historical background. Because insurance companies didn't like cooperatives to join to compete with them. So they have omitted cooperatives to be included in the Insurance Business Act. So as a result, in Japan, special provisions have been established in the individual cooperative laws for insurance business. So the provisions of the Banking Act and Insurance Business Act apply mutatis mutandis to cooperatives. There are many such provisions borrowing those business acts, business laws. So in fact, those banking or credit cooperatives, insurance cooperatives are controlled not only the competent ministries, but also the financial service agencies. Membership is strictly defined, and the problem with the Agricultural Cooperative Act is two categories of membership: full farmer members and associate members who just use financial and other services. They are not farmers, they are consumers or small minor enterprises. But the fact that such associate member outnumbers the full members creates the moves to set up a cap to the use of associate members to a half of the usage of full members. That is very ridiculous regulation. In a year or two, the government will decide on this, but it's very nonsense. That is extension of very rigid prohibition of non-member business. That is very anachronistic regulation, I think. Activities. Each law listed the activities that cooperatives can undertake. But Consumer Cooperative Act does not allow consumer cooperatives to conduct credit businesses. So consumer cooperatives have been handicapped. And Consumer Cooperatives Law Act perfectly prohibits non-member trade as a result of the retailers' campaigns against large retailers. And they have made consumer cooperation as a scapegoat. Still, such very strict prohibition applies to consumer cooperatives, while other laws permit 20 or 25% of members' trade for non-member business, for non-member use. Governance is almost same with many laws, but Agricultural Cooperative Act provide for the option of the dual board system, supervisory board and management board. In Japan, only agricultural cooperative law, such a provision is established. But it is not so popular amongst agricultural cooperative people because it may be creating the overlap by two types of board. So they don't like it. The compulsory audit by accounting auditors was introduced to Consumer Cooperative Act in 2007 and Agriculture Cooperative Act in 2015. But before 2015, the Central Union of Agricultural Cooperatives can audit the affiliated agricultural cooperatives. But that has been changed to the compulsory audit by professional auditors, accountants. Financial structure, the rate of dividend on share is limited to 7 to 10%, while patronage fund is preferred and paid tax-free. But in Japan, we have no provision of indivisible reserves. So we can distribute the residual assets of cooperatives among members when the cooperative is dissolved. But most of cooperatives have their bylaws that stipulates that such residual assets will be transferred to other cooperatives or to the state. So that is a practice. But in case of JA Welfare Federation, Hosei, that is cooperative hospitals and clinics, they are designated as public health care providers. The asset lock is applied. So residual assets cannot be distributed among members. So only in case of the such medical cooperatives of agricultural cooperatives, such an asset lock is applied. There is no provision on investor members. And supervision, I already mentioned. Taxation, I mentioned. But the difference between the corporate tax rate between the conventional companies and cooperatives has been reduced from 12% to 4% during these 2 decades. So it's very small now. About workers' cooperatives, I just mentioned that there are 2 streams. One is Japan Workers Co-operative Union that emerged during the 70s from a trade union of middle and old-aged workers temporarily employed by the National Employment Scheme, Relief Scheme. This tax-funded project provided daily employment in civil engineering, public sanitation works for unemployed people. But it was gradually dwindled and finally terminated 71. So they have transformed to workers' cooperatives. And when the Long-Term Care Insurance Act was introduced in the year 2000, many workers' cooperatives had undertaken such an elderly care services. The second stream is represented by the Workers Collective Network Japan. That is smaller than the first one, but they are basically very small in number. But they are the, so to say, the offshoot of the consumer cooperatives named Seikatsu Club. So most of the members are women and housewives. So originally, they had worked for the consumer cooperation in a warehouse or in the store operation, but later they have entered in the catering, community cafe, elder care, child care, editing, translation, etc. Both groups were inspired by Ledrow's report, and since they lacked the legal instruments to incorporate, they had to rely on the different organizational forms, such as limited companies, consumer cooperatives, enterprise unions, and nonprofits. And they have campaigned to enact their own law. And finally, they succeeded to pass the diet, the new law, the Workers Co-operatives Act. So purpose of law uh, provides for the basic principles of workers' cooperatives. They are the members share invest. They three principles are members share investment, reflection of their voice in conducting businesses, and their engagement in cooperative activities. And upon registration as the main office address, a cooperative is incorporated without any government permission. And membership, minimum membership is 5, very small compared with consumer cooperatives. In that case, 300 members as a minimum members. More than 80% of members need to be engaged with cooperative operations, while more than 75% of engaged workers need to be members. Scope of activities is limitless, except for workers' dispatch business. Of course, in case of the bank and insurance businesses, they need to have the special permission from Financial Service Agency. The governance need to have bylaws and rules. And distribution surplus workers corporates are subject to government, sorry, uh, surplus can be distributed only after offsetting losses, deducting legal reserves and reserves for job creation and education. The dividend is distributed to the members in proportion to their contribution of work, not shareholding. Tax concession. So far, there is no tax concession for the corporation tax, corporation income tax. But so far, they can enjoy the lower tax rate applied to small and minor enterprises. That is identical to the rate for cooperatives, the reduced rate, 4% lower than the conventional companies. And government supervision is still applied to workers' cooperatives. So the impact to the Workers' Cooperative Act's impact to the existing legislation. Firstly, the mode of establishment is very simple, namely workers' cooperative can be incorporated after legislation, while government permission is not required. So that is common practice in most of the industrialized countries, and the Japanese companies follow this rule, while government still require the permission for other cooperatives and non-profits. In this regard, WC Workers Cooperative Act is a breakthrough to bring about more liberal legislation. Secondly, the membership is not limited to a specific class of people, while the minimum requirement of 5 members is extremely low compared with other laws. This characteristic enables a small number of citizens to set up a cooperative to meet their needs much easily. Thirdly, a range of activities is not limited, and potentially any kinds of activities are possible. In addition to care workers cooperatives that are operating in many places, doctors cooperatives or renewable energy cooperatives are possible. Conclusion. The fragmented cooperative legislation linked with industrial policies and different regulators creates problems associated with bureau pluralism and hampers cooperatives to foster the identity and address new needs. The enactment of the Workers Co-operative Act can be seen as a breakthrough in the Japanese legal system. There is a huge potential of cooperative development to meet the pressing social economic needs, especially under the growing unemployment because of COVID-19. So there is great potential. We have to make use of this potential. The possibility. So finally, the possibility of enacting the Framework Act of Cooperatives or the General Cooperative Act should be explored. I have made a proposal for the Japanese Framework Act of Cooperatives following South Korean example. Of course, we need to have the consensus among cooperative leaders, and of course, we can pass through the parliament. So I see many years to realize such kind of the general act or framework act of cooperatives to be enacted. But that is our future vision to establish such kind of cooperative law that can help cooperatives to make full use of cooperative enterprise and in meeting many kinds of needs we are facing. So far, it is very difficult to address such specific needs and to establish a cooperative that can meet with such needs, pressing needs. Thank you for your attention. Okay, Davi, I shall stop here.
Okay, merci beaucoup. Sorry, thank you very much, Akira. I was switching to French. I don't know if you expect to have the questions right now, or we give the floor first to Anne and then we will collect the different questions.
I think it's better.
What is the
after Anne's presentation, we receive questions because we can compare the Japanese and cases in the Pacific.
Okay, so I give the floor right now to Anne.
Thank you so much, and thank you so much, Professor Kurimoto. It was a fantastic presentation, and I have received some messages from some Australian friends who are saying, wow, we didn't know that there could be so much difference between different systems of cooperative law. So I think it's wonderful for us to be hearing about Japan, and we can give a plug for the second webinar, which will be later this year, which will look at the Korean framework. So we can learn more about this as well. So just trying to. So I'm hoping that's okay. Is that visible to everybody?
Okay.
Thanks so much. So my presentation is about cooperative law in Oceania, and it's a little different to Professor Kurimoto's presentation because his presentation was a deep dive into Japan, and while I'm probably most comfortable looking at Australian cooperative law, I was going to just do a broad sweep across some of the countries, not all of them, but some of the countries that I looked at as sub-regional expert. And the area that I was looking at for the legal framework analysis was Oceania. And Oceania is not a word that we hear all that often, but of course we're talking about the islands that are situated, including Australia, but in the Pacific Ocean, and particularly to the east of Australia, and that very big expanse of Pacific Ocean that lies between us and the Americas. So I'm mainly going to have a look at cooperative law in Australia, New Zealand, Vanuatu, Kiribati, and Fiji. I also did have a look at Papua New Guinea's law, but I'm a little less familiar with that law, so I've left it out of this presentation. And what I'm intending to do is to sort of give a very broad and general overview of the laws in each of these countries and focus in on some of the particular features. And this is, I think, really useful when we go back and compare to Japanese law and the sectoral approach that they have in Japan, and the very broad and general approach that we have adopted and is adopted in and has been adopted in common law countries as compared to civil law countries. So Oceania, I just popped this map up so that you can have a little bit of an idea of some of the location of the areas that we're talking about. Of course, Australia and New Zealand are the larger land masses there. Papua New Guinea to the north. But I'm also looking at Kiribati, which is fascinating because the islands across Kiribati are actually in all four zones in the world. So on both the north and south side of the equator and on either side of the dateline, which makes it a very fascinating region. Fiji and Vanuatu, you can see here towards the middle of the map. So in terms of landmass, these islands are amongst the world's smallest, and population also very small. But of course, what's so important about them, why this area is so very important, is because of its strategic location and the importance of the Pacific Ocean in terms of supplying the world's food from its fisheries. And also so much of our weather is generated from the Pacific Ocean. And this is something that we're very aware of in Australia at the moment, because we're experiencing the impact of the reversal of the currents in the Pacific Ocean. Last year, the currents caused intense heat waves, and it was very dry, and we had bushfires up the coast. This year, fortunately for us, the currents are going the other way, and we've had a lot of rain, and that we've seen an incredible amount of regeneration after the fires. So the Pacific Ocean is so incredibly important. So just to tell you a little bit about Australia, it's a large continent surrounded by not just the Pacific Ocean, but also the Indian Ocean to the west. And for many people, to travel to Western Australia is like traveling to another country. It takes about 5 hours on mainly an international flight or domestic flight from Sydney to Perth. And there are significant differences between the states, and anybody that lives in Australia during COVID has become acutely aware of the fact that for a long time, these states operated as if they were separate colonies. They were separate British colonies, so they operated like different countries. Now, we'd forgotten that until COVID came along, and what we've seen during COVID is that the states quite readily put up border controls. So we're experiencing a sort of a throwback to our colonial times, in the sense that the various states in Australia are operating quite independently in terms of the way they implement policies through COVID. So I mentioned this because it's really a significant barrier to cooperative development in Australia, because cooperative law is regulated at the level of the states, whereas company law in Australia is regulated federally. And what we've seen is that Australian politically lawmaking has become much more centralised in Australia, and as corporate law moved to the federal sector, so did much of the lobbying for business law reform. The co-ops being regulated by the states suffered a resource drain. So the registries are very small and they're not well resourced. So that means that we don't have the same sort of flourishing sector that we had before the centralisation of power or the centralisation of business law in Australia. So we do have now a uniform law, and we've had a significant amount of law reform since 2012, which has been interesting, particularly because it has drawn the attention of everybody to cooperative law. And this is something that I think is of interest, and I'll mention it when we look at the other countries where there has been some stagnation in law reform. There really is an advantage in having law reform, and in Japan, the new Workers Cooperative Act will certainly, galvanize some attention among people that are interested in cooperatives, because law reform tends to generate interest. So I think being active in the area of law reform is very important for co-ops, and it's a problem when co-ops stagnate as far as law reform is concerned, because it becomes forgotten. We have a very general, compared to Japan, we have a very general cooperative law in Australia. Even though it operates at the level of states, we now have effectively a uniform law, because each state has adopted the same model template law, except for Western Australia, which has a consistent law. It's a partner to the agreement. So the states all agreed to adopt consistent laws. It's not the same, and it creates confusion because it's called a national law. People assume that we have that there's not much difference between having a federal law and a uniform state law, but there is a big difference. And certainly it has to do with the resources that are attached to the regulators. I think the grass is always greener, and whilst Professor Kurimoto has told us about the problems that you have having sectoral laws, and how he would very much like to see general laws, a general framework law, which is much more flexible. In Australia, we have the advantage of having a general framework law, but the payoff is that we have shrinking sectors, like we have a shrinking industrial sectors. So agricultural cooperatives have been shrinking. That sector has been shrinking. It was once quite powerful. It's now comparatively small. And we have very few consumer cooperatives left. We are seeing growth in some of these innovative areas, and the law is flexible enough to accommodate multi-stakeholder co-ops. It's also flexible enough to accommodate sort of innovations in the area of care and care services, like in the disability and health sectors, and also in the area of renewable energy. So the flexibility of the framework has advantages, but the lack of political support has created conditions that are not favourable to those sectors which were once large and thriving, and they have been shrinking for some time. So it means that the co-op sector in Australia is quite small. And of course, where you have development, it will take time for it to grow again. New Zealand's very different from Australia. While we consider them our cousins in so many ways, and we have some similarities in our history as settler colonies with significant British and European migrant populations, New Zealand doesn't have, it's quite unified, and it's very much quite homogenous in terms of its industrial activity, which largely centres around agriculture and exports. And at the centre of the agricultural sector is the dairy industry, which is very strong. So despite the fact that, like Australia, it deregulated the dairy sector in the 80s and 90s, it continued to support the cooperative sector. In fact, the marketing boards essentially were handed over to a super cooperative, which is Fonterra, and that cooperative is very large and is not just a powerful force for the agricultural sector. I guess it underpins the strength of the co-op sector in New Zealand. So one of the unique features of the New Zealand co-op law framework is that it has a Cooperative Companies Act, which is a hybrid, and Fonterra as a dairy co-op is registered as a company, but also registered as a cooperative company under that act. And this is very much adopting the sort of new generation co-op principles, which agricultural cooperatives in North America have also sort of, it's become quite popular there. So we don't see that so much in Australia. There's no distinct cooperative companies legislation, although many agricultural co-ops did register as companies in Australia, primarily because there weren't adequate laws for agricultural co-ops for much of their history. New Zealand still has an Industrial and Provident Societies Act, and it hasn't been reformed or updated or reviewed for a very long time, but there are still many active service co-ops that are registered under that law. So it has both in the system. Now, just a little bit about the Pacific Island, the laws for co-ops in the Pacific Islands. Just quickly looking at Vanuatu and then Kiribati and Fiji. These Pacific Island states were all colonized by the British to some extent, and that's probably an important point compared to the colonization that took place in Australia and New Zealand. The depth of colonization in these countries varied, but in many of these countries, although there were British protectorates, they were mainly set up in in one island, and yet these nations, Vanuatu, Kiribati, and Fiji, are archipelagos of hundreds of islands, and the Brits didn't really expand their colonization to many of the islands. And the law that was introduced in these countries was the ordinance, which was the British Indian Pattern for Cooperation. So it was an ordinance that was developed based on the Indian cooperative law, and it was applied as a model or template law throughout the Pacific Island countries. When they became independent, which happened in the 70s, most of these countries retained that framework, and certainly that was the case in Vanuatu, Solomon Islands, and Kiribati. Originally Fiji, and I'll get to them in a minute as well. So Kiribati is different in the sense that it is a very spread out and very small islands that are spread across those four sectors. And it's very hot in this area, and there's not a lot of land mass. So there's not a lot of agricultural industry, and they're very dependent on the ocean for their food source in this country. They also applied the ordinance. So the Cooperative Societies Ordinance is the original British ordinance, and it's been changed very, very little. The credit unions and savings and loan societies in Kiribati are separately regulated, and that's I think that it's not the same in Vanuatu, though they've been recently introduced some changes. Fiji, similar, but of course it was a much larger colony, and it's probably the most advanced of the Pacific island nation economies. It has a strong tourism, forestry, and fishery industry. All of these countries didn't get their independence until the 1970s. Since independence, we've seen quite some emphasis on the development of cooperatives in Fiji, and they reviewed their law in 1996. And the interesting thing about that particular revision is that it was very much guided by recommendation 127, ILO recommendation, which was the predecessor to 193. So it's quite an update, a significant update from the ordinance, and it has some good features. So it's worth looking at. It's an interesting law. It's quite clear and easy to navigate, but whether it's satisfactory for Fiji is something that Fiji is currently exploring. So we've talked about the fact that because these were all former British colonies, including Australia and New Zealand, we all received British law. And that means that we operate under a common law system, which is quite different to the civil law system that is in place across most of Asia, Japan, China, and of course, through most of Europe. So the common law system you'll see in Australia, Canada, United States, though it's a modified version of. And it means that we do have this very general legal framework that's quite flexible and adaptable. But of course, we compare civil and common law systems a lot, and there are strengths and weaknesses in both. And I guess the grass is always greener. So we look at civil law systems and think that there are some things in those systems that probably are better for cooperatives. Certainly in many countries, they're based on they're much friendlier to collectivism, I think, and solidarity than common law systems, which are very much developed around individualism and private property rights. And I think that's always something that the cooperative model struggles with in common law systems. So Vanuatu and Australia have had the most recent overhauls of their cooperative laws. And I think, as I said before, that means that they have had some attention. I might just have to speed things up. I'm mindful of the fact that it's quite late, particularly for the Australian audiences. But just quickly about governance, the extent to which any co-op law operationalizes co-op principles can influence the effectiveness of co-op governance, but it's important to recognise that there are other factors that will always be at play, and these include institutional, cultural, and other regulatory institutions, including other laws, including tax law, finance law, employment law, and so on. And of course, you can have a very good law on the books, but if it's not reviewed, monitored, and supervised, then it may not necessarily enhance the cooperative development. So in terms of governance, the New Zealand Cooperative Companies Act stands out as quite different. It doesn't enshrine the democracy principle of one member, one vote, for example, whereas all of the other laws do. There are shareholder limits in most countries, so an individual can only can't have any more than 20% of shareholding. That's common throughout most of the jurisdictions, but under the Co-op Company Act, the only real limitation on shareholding is that transacting shareholders must have 60% of the voting rights. You can see the differences in minimum membership, but compared to Japan, where you have to have 300 members for a consumer co-op, the numbers are quite small. Of course, the actual framework adopted by the various co-ops, the flexibility to have different types of co-ops will be very much reflected by their constitution and bylaws. And most countries provide model bylaws. The registry may have sets of model bylaws or rules for co-ops in particular sectors. Australia doesn't really have a repository they do have some general model rules, but they don't have model rules that are tailored for particular sectors, though I know that Vanuatu does, and I think Fiji also does. In terms of governance, in the Pacific Island countries, they can only have co-op members on the board. In Australia, you can have non-member directors, but your active members must always be in the majority. And under the Cooperative Companies Act in New Zealand, that the law doesn't require transacting members on the board, but it may be a requirement in the Constitution. I'm going to talk a little bit about penalties, but I'll leave that. I'll come back to it. So supervision, monitoring and enforcement, as I mentioned at the outset, is really a big problem for all of these countries, including Australia. I think probably in practice, New Zealand probably has the strongest supervision, monitoring and enforcement, because it's very much, it's a very large sector, and it's very prominent, and it's very attached to the same regulator as company law. The problem with supervision, monitoring and enforcement by the registries is that regardless of what the law says, the registries need resources and funding to be able to actively supervise, monitor and enforce. And if they don't have those resources, it's impossible for them to carry out that task effectively. And it's not just in the Pacific Islands that that's a problem, that's definitely a problem in Australia too. In terms of auditing, none of the common law laws in these countries require a non-financial audit, such as in Europe. So typically in some of these Pacific countries, particularly those with the earlier British Indian pattern of cooperation, the registry was required to have a very paternalistic role and essentially not only supervise, but also nurture and develop cooperatives. There have been very recent changes in Vanuatu which have shifted some of the business development function away from the registry, which is probably a good thing if it doesn't have the resources to carry out that function. But whether that function can be well addressed by other bodies there's also that problem if they don't have resources. In terms of financial auditing, in Australia and New Zealand, both of them have laws that say that if you're a small co-op, and small is measured in terms of revenue, assets and employees, you can opt out of an annual financial audit as well. The cooperative company, the directors have to pass a resolution every year saying that during the relevant accounting period, the company has been operating as a cooperative company. I think that's really interesting. I think there's potential to do something with that in terms of looking at laws in different countries and thinking how they might be applied and adopted. I very much like the idea of directors being required to make an annual, pass an annual resolution, like a solvency resolution, to say that they're, to put their own integrity on the line, to say that their business is operating as a cooperative, depending on how that is defined in the legislation. Fiji's Act has supervisory committees, and Professor Kurimoto also mentioned those in Japan. I don't know whether this, how effective this is in practice, but it's interesting that it's part of the Fijian cooperative law. It only applies to larger co-ops, but it allows the members to be able to sort of supervise the board. There's a new innovation in the Vanuatu Act where the minister on the recommendation of the registrar can ban a person from being an officer or a member of a co-op. I thought that was interesting in a common law jurisdiction because it's actually an administrative law procedure and there doesn't appear to be any process for judicial review. So this is a decision made by a minister on the recommendation of the registrar. and that sort of thing is not typical in a common law jurisdiction. So it was an interesting innovation in the new law. It's worth mentioning that Australia, the co-op national law has adopted some ideas from reforms of company law, and one that is worth having a look at in other jurisdictions is the idea that when you prosecute for breaches, there's such a thing as civil penalties. What it means is that the registrar, when seeking to prosecute the directors or a co-op for breach of the law, isn't held to the same high standard of proof as they are for a criminal trial. So it's a civil procedure. It's like a hybrid. Penalties are imposed, but it's easier for them to successfully prosecute a breach because the burden of proof isn't so high. Just a little bit about reserve funds. So Kiribati and Vanuatu both have indivisible reserve funds, and so does Fiji. Australia and New Zealand do not have divisible reserve funds for distributing co-ops in Australia, but we have non-distributing co-ops, which are non-trading co-ops, and it's suitable for not-for-profits, and they have an asset lock. Of course, they can get around the asset lock by changing, by special resolution of members changing to a distributing co-op before they, demutualise. But that has to be approved by the registrar, so it's not necessarily an easy thing for them to do. Capital raising varies. The interesting thing is looking at New Zealand, which has this new generation co-op, which allows the linking of shares to patronage. So on that model, those shares can be traded. And of course, this allows the members to realise some capital gains. The value of the shares is not just nominal like it is in most cooperatives. And we can debate, it's an interesting debate, the new gen cooperative model, but I know that it's certainly allowed large scale agricultural cooperatives to compete in a hyper competitive environment. So the question is this a good thing or a bad thing? Should we allow this sort of hybridity? And certainly New Zealand has done this successfully for some time. In Australia, we've got cooperative capital units, which is a hybrid instrument. And hybrid instruments are there in many, in various iterations, various ways in various cooperative laws. CCUs, even though they exist and they can be used by non-members, they can be purchased by non-members and they can be structured as debt or equity, they haven't proven to be very popular. So the market has really not taken to them. And it's interesting to look at why. So I've mentioned them. Sorry, I'm just trying to flick through. Just quickly, taxation. In Kiribati, the co-ops don't get any special tax treatment. In Vanuatu, they don't either, but it's interesting, Vanuatu doesn't have an income tax system. They raise taxes using other taxes like VAT and land tax. Fiji does offer tax incentives similar to in Japan for small enterprises and new co-ops. They can get tax exemptions, so there's considerable income tax incentives. In Australia, there are limited tax incentives. There used to be an incentive, but it's largely is the lack of double taxation that used to apply in the company sector. But now that that companies can have franked dividends, then that dividend imputation system means that there's not a huge advantage in the difference between co-ops and companies. There is the possibility for certain cooperative companies to get a government loan, which is tax-free in terms of repayment. They can claim not just interest, but capital repayments as a tax exemption. And that's been used successfully by some of the larger co-ops if you can access government loans. But otherwise, there's not a great deal of tax incentives, and they don't pay a lower tax than the corporate tax rate in Australia. So just in summary, there's a lack of regular review of most of these frameworks, and my point is that it's great to have law reform because it brings the attention of politicians, academics, and everybody else to the cooperative model when there's some significant reform. The lack of law reform in some of these areas may be a lack of political support, or it might be a lack of resources in the sector to lobby for that reform, or a combination of both. So there are recent revisions in Vanuatu and Australia have successfully created some interest in cooperative law in those countries. And I know that Fiji is very keen to review its law. But of course, cooperative law is only part of the puzzle, and modern competition, taxation, finance and labour laws can have a huge impact on the cooperative sector. And we've seen this very much in Australia. If the country adopts a one-size-fits-all model and doesn't recognise the cooperative difference, then it's very difficult for cooperatives to develop and grow. And that's the end of my presentation. Thank you, everyone, and sorry to keep you up so late.
ANAPS a arrêté le partage d'écran.
Very much. Well, time is running, of course, but I think that we can take 10 minutes or a little bit more for questions. So please feel free to intervene and ask questions to either or both.
Continue professeur ANAPS série informative. Erreur d'identité tout le monde. Continue professeur ANAPS série informative. Zoom U. 4 Martin a quitté la réunion.
I know that everyone wonders if he's allowed or she's allowed to ask questions. So please feel free to.
So if I may, David, I feel free to, first of all, it's Hagen speaking.
Yeah.
To first of all, thank both presenters for equally interesting presentations of quite different nature. I have a question for Akira and a remark or question for Anne. Akira, does the new Act on worker cooperatives deal with the, I suppose it does, and how does it deal with the relationship between the cooperative law, worker cooperative law, and labor law in general, in the widest sense, including social protection and social security issues? And for Anne, did I hear you correctly when that you said that on acting upon the demand by the registrar, the minister may step in and deal with issues of bad management or something at the board level, and you called it an innovation. I would like to point out that in the past, this was quite a widespread, I think, bad habit, especially in the so-called Anglophone countries, which we try to do away with where that still exists. So thank you.
Yes, thank you for your question. Akira is speaking now. About the relationship between the Workers Co-operative Act and labor law. As a matter of fact, it is the biggest issue before we can succeed enact this Workers Co-operative Act, because there are some strong opposition or questioning from the trade union side. If workers cooperatives can employ the workers who are not protected by the labor law, that can create the second labor market. So they are very skeptical about such case. So and also the Liberal Democrat Party, the ruling party, suggested that if you are the owner of the cooperative, so in that case, that may have some questions about the status of us workers. So from both trade unions and from the Liberal Democrat Party, there are questions about the relationship between the corporate law and labor law. And people are not so accustomed to and prepared to such questions. So it is often insisted that among the workers' cooperative people that we are not employed. We are doing the joint work, or so to say, associated work or cooperative work, not employed work. But as a matter of fact, it is not possible. It was not possible to pass the act without the consideration on the labor law. So the enacted new law on workers' cooperatives has a provision that the workers have to conclude the labor contract or employment contract with cooperative, so that they can be protected by the labor law. So that is how the legislature had solved this problem. So every employee or workers in the workers' cooperatives should have the contracts, labor contracts with the cooperative as an employer. So that is how they have solved this problem. And without such a solution, it was not possible to get consensus amongst all parties, especially with trade unions. So that is what we have experienced in these years. And that is one reason why the enactment of Workers Cooperative Act was so delayed. It took about 2 decades to enact this law compared with other laws that had been created only within several years, 1 or 2 years. So in any case, that is a very crucial point when we are now analyzing the Workers Cooperative Act about the existence of the labor contract. And upon labor contract, we can protect the workers' rights and working conditions. So we can't avoid that to avoid the second labor market situation. So that is what we have discussed. And we have concluded that we should have the labor contract provision.
Thank you.
Just in relation to the banning orders, I just noticed this was, when I say an innovation, this was something that was just recently introduced in Vanuatu. They introduced some reforms in 2019. It's the banning orders. I'm not familiar with the history of banning orders in other countries, but for example, in Australia, if a director was in breach of director's duties and they were prosecuted successfully, then the prosecution, so the registrar who launched the prosecution, can apply to the court to have that director disqualified from being a director for a period of time, and that would be a director of any cooperative. Of course, there's nothing to stop them. I think the crossover, nothing to stop them going on to be a director of a company at the moment, and because those two jurisdictions don't match up. Yeah, the thing that interested me about this was that there seems to be no mechanism for judicial review. That was all. I was curious about that.
Thanks.
Sont actuellement activés.
Thank you very much. Another question?
If I may.
Yes.
David?
Yes.
Thanks for both presentations. They were very informative and inclusive. I have one question for Professor Kurimoto and one question for Professor Ans. I will start with Professor Kurimoto. Currently in Greece, we are in the process of start discussing and we have drafted the general law on cooperatives because we are facing also the same problem of cooperative law fragmentation. So I would be very keen on hearing why do you think it would be for in the case of Japan, what would be the most important consequence for a general cooperative law, one point. And second point, it has to do with the process. If I understood you well, you said that this is the future vision for Japan to have a general law, and you have drafted or you are in the process of drafting such a law. And I would be very highly interested to hear what is the next steps. And yeah. And for Professor Abs, I would like to hear more on the asset lock. You said something, if I'm not mistaken, that the demutualization of cooperatives is prevented because there needs to be a certain license coming from the registrar. But please go ahead and clarify that. Thank you.
Thank you for the question. First of all, the Framework Act may contain two major elements. That is the general provision on cooperatives or the principles which we can use as a legal norm of the cooperatives. So such an element of the, so to say, the law on the general status of cooperatives, that is one element. The other element is to enact the law which enables us to establish the cooperative more freely without the specific industrial policy objectives, without a very strict membership, without limitation to the activities of businesses, so that we can more freely design the new cooperatives. So that is, so to say, the general cooperative law. And in case of the Korean Framework Act of Cooperatives, it is composed of three elements. One is stipulating the general principle of the cooperatives. Second one is the general cooperative law. The third one is social cooperative law. So in their case, in South Korea, there are three elements in the Framework Act of Cooperatives. But in our case, it is, of course, it requires another discussion on how to create the social cooperatives. That is very important sector of activities. We have the healthcare cooperatives and social service cooperatives. They are doing very good jobs and playing a very important role in securing, providing the healthcare, especially health promotion services or prevention services among people. So, but we don't have the Italian type social cooperatives. But that part is played by non-profits in Japan. That is social service corporations. That is also semi-governmental body, very much regulated and supported by the government with tax. And at this moment, it is not, it seems not possible to replace such a social welfare corporations with new social cooperatives because they have very strong power in the political scene, and they may oppose to the new generation, new types of cooperatives, social cooperatives, which may replace such non-profit organizations. So that is why I have prepared the draft, the proposal, which contains just two elements. That is the general cooperative principles to be included in the more general one. And the second one is to enable people to establish the more general cooperatives without any binding of the industrial policies or membership or activities, such many restrictions we don't like. So such an law should be enacted. That is my idea. And secondly, of course, it takes steps. More than 70 years, people had lived with the existing cooperative laws, more than 10 cooperative laws. So, and they are, of course, fitting to the current cooperative structures, leadership, etc. So it will take time to think about more general law that can enable us to do much more things, but it requires time to generate some consensus amongst, first of all, leaders, cooperative leaders. Without support of the cooperative leaders, we cannot go to the politicians, legislature. So we have to do such a proposal step by step. But at least in the research circle, there is some kind of the consensus that we need to enact new types of cooperatives, not just adding the new specific laws, but more general law we should establish. That is some kind of the consensus. And now Japan Co-operative Alliance will discuss about my proposal. So, and then that proposal will be discussed among cooperative leaders, but it will take time before going to the parliament. So that is what we are thinking.
Many thanks, Professor Kurimoto. Thank you.
My apologies, Iphigenia. I worked out now what I said that raised your question, so I can answer it. The asset lock for non-distributing co-ops. So the cooperative national law in Australia recognises distributing co-ops and non-distributing co-ops, which are essentially non-trading co-ops. There are advantages not just under the legal framework for cooperatives, but also those co-ops can register as charities and they can get some special tax exemptions as not-for-profits and so on. To qualify as distributing co-ops, they have to have an asset lock, which means that not only do they not distribute surplus to their members, but they must also make a provision that on a winding up, a dissolution, the assets of the cooperative go to another not-for-profit organisation. It doesn't necessarily have to be a co-op, but ideally something with similar objectives. It's possible that a cooperative that was a non-distributing co-op could pass a special resolution to convert to a distributing co-op. That's possible. And then upon dissolution, the assets would be distributed amongst the members. The protection, the only protection is that any application to convert, so even if they did pass a special resolution, the members, to convert from non-distributing to distributing, they have to get the approval of the registrar for that conversion. So you would hope that the registrar would say this is not an appropriate conversion because you're just converting so that the members can take the money and run. Does that make sense?
Thank you.
Puis rétablir en audio, bouton. Tout le monde, tant qu'il se mouche fort de présentation. De passer tout le monde, tant qu'il se mouche fort de...
Professor Souchon wanted to ask a last question, so I think that we are able to do, but quite quickly, please, for the question and also for the answers. Thank you.
A lot. I'm from Poland and I would like to ask about the agriculture cooperatives because I generally occupy agricultural law, and Professor Kurimoto mentioned about some regulation in Japan from 1947 about agriculture cooperative. And I would like to ask about present regulation. Is this regulation still exists, or there is some other regulation in Japan concerning agriculture cooperative? And agriculture cooperative are popular in Japan? And about organization, is there exist any organization of agriculture and fisheries cooperative in Japan? And the same a question about Australia. Is there exists now some separate regulation about the cooperative in Australia or in New Zealand? Because in New Zealand there exists a lot of milk cooperative. So my question about the regulation. Thanks a lot.
Thank you for your question. In Japan, agricultural cooperatives are so strong organization in Japan, and they are seen as a biggest pressure group to the government because they can mobilize votes of farmers and money in the election. So they are always supporting the ruling party, the Liberal Democratic Party, the Conservative Party. And so they are very strong in the political scene, and they enjoy all the advantages and the privileges that has been given to agricultural cooperatives by the government. So in my opinion, they are too much protected, or too much, so to say, regulated and protected. So it is, so that is why the agricultural cooperatives, they say themselves JA, Japan Agricultural Cooperatives, JA. JA is often seen as a government agency, government agent and the pressure group and cooperative per se. So that's true. And so what I think is that they should be more independent and autonomous in policy making. All the agricultural policy was given or decided by the ministry, and they are seen as an agent to implement such a public policy. So in this regard, they are a very strong instrument of the government. And because of that, they can gain very strong political power. So in the past, the rural votes is very big, and especially in the rural area other than Tokyo, Osaka, the LDP, the Liberal Democratic Party, had been supported by those votes in the rural area by agricultural cooperatives. So that is why agricultural cooperatives are very strong in the political arena. But the things are changing because of industrialization and especially globalization. Such a protection had been removed step by step. So nowadays, the Japanese farmers have to compete with farmers outside. And especially the neoliberal policy pursued by the current government had undermined such a protection which had been given by the government to the agricultural cooperatives. So as a matter of fact, the Agricultural Cooperative Act was amended in 2015, just 6 years ago, but that was imposed by the government to the agricultural cooperatives. They basically they opposed to that regulation, but the government imposed such a new amendment to agricultural cooperatives. So, but still, they're very much dependent on the government policy, especially agricultural policy, because of the various kind of the protection of the domestic agriculture. So that is why in Japan, the custom for importing rice is 800%, or almost prohibitive percentage, because that is the very stronghold of Japanese agriculture and agricultural cooperatives. They wish to protect the domestic agriculture against the international competition. So in this regard, the agricultural cooperatives have been protected from the competition, domestic and the foreign competition. But now things are changing because of globalization and neoliberal policy of the government. So we have to think about how to be more independent, and we should build up a strong membership base and business base of agriculture cooperatives. Otherwise, it will be reducing its position in the national economy and among people. So I don't like to see that. So I'm now supporting agriculture cooperatives, but pushing them to be more, so to say, independent from government policy. So that is a very complicated problem, combining the agricultural policy for protection and government policy on agricultural cooperatives. So there are many differences now between the government and the agricultural cooperatives, but still agricultural cooperatives are under the very strong grip of the government. So we wish to change it to be to do as the Western cooperatives, agricultural cooperatives will do in Australia, New Zealand, or Europe or North America. But even the researchers, they do not see how the agricultural cooperatives in other countries had made efforts to modernize its services to serve the members and to introduce new idea of, for instance, new generation cooperatives. That is a kind of the hybrid between cooperatives and joint stock company. But still, we don't see such an solution, and we are not so attentive to such an struggle of agricultural cooperatives in other countries. We have to learn from those experiences. So that is my answer.
Thanks a lot.
I think because everybody's probably getting quite weary, I'm going to keep my answer very short. But it's so interesting to listen to Akira, because I'm working on this as well, this researching in this space. In Australia, we don't have any, not only do we have any special laws for agricultural cooperatives, we have a deregulated environment that is very neoliberal, and it has made it very, very difficult for dairy cooperatives, for example, to survive at all. We used to have a sector that was quite protected, say milk, for example. It was regulated, very protected, but it also had a very strong cooperative sector that started at a time when there was no government intervention, but also grew and got stronger through a period of government intervention. But at the other end, with deregulation and a very hyper competitive environment, most of the dairy cooperatives have demutualized. So we've gone from having a sector that was dominated by cooperatives to pretty much there's one significant cooperative left in that sector, and it finds it quite difficult to survive. New Zealand's very different. They have the New Gen Co-op, but they also have a government that has essentially just shifted its attention from a marketing board to one dominant co-op, which provides the sort of the base co-op in New Zealand. And so there's very strong support for that co-op politically, as well as, through its very big membership base and its importance to the New Zealand economy. So they've gone down a very different pathway to Australia. So it's very interesting comparing the two countries in terms of their approach. I don't think they could be duplicated, though. I think that both countries have very different agricultural sectors. There are so many other factors that come to bear on this. And I think one really interesting thing to bear in mind is that agriculture in New Zealand, it's quite homogenous. Beef, lamb, milk, with a very strong export focus, makes it very easy for them to sort of have a very strong and unified policy around agriculture. Australia is much more diverse, and the states get themselves all tied up in state and regional politics, to the detriment of co-ops, as it's turned out.
Thanks a lot.
Thank you very much, Anne and Akira. Well, I think it has been. Sorry, I think it has been very stimulating, but time is running, and I think that everyone is less attentive than at the beginning. So I'm going to close this session, but I can confirm what Anne said about next session in June. And so I'm very happy, and I hope that you will join us as well in June for the next session. So thank you very much, and have a nice day or a nice evening.